You're good to go. Welcome to the regular meeting of the San Francisco Ethics Commission. We'll begin by taking the roll. Vice Chair Rennie.
Present.
Commissioner Andrews.
Present.
Commissioner Hayon.
Here.
Commissioner Keene.
Here.
The first item on the agenda is public matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
Yes, good evening. Thank you. I attended a Sunshine Ordinance Task Force meeting on August 6th. At that meeting, a very unprepossessing young man played a tape recording of your Ethics Commission meeting. Featured in that audio recording was primarily your Commissioner Keene praising this young man rather extravagantly because, according to Commissioner Keene, he had successfully prosecuted a ethics complaint, and according to Mr. Keene, quote, hundreds of people in the same situation would have given up. Really? Are the obstacles to a successful Ethics Commission complaint so high that only a fraction of 1% can expect success? Does Mr. Keene tell his business associates and his neighbors, I'm on the Ethics Commission, it's dysfunctional for less than 1% of the population, I'm in charge? A very strange thing to be proud of. Don't we want to live in a society where access to an Ethics Commission complaint is the lowest, not the highest? That raises two questions. First of all, how do all of these people supposed to feel knowing that they are not competent to pursue an ethics complaint, a successful ethics complaint, because the barriers are so high that more than 99% of them would give up? And more importantly, do we want an ethics complaint to be the most exclusive club in town? In fact, an Ethics Commission complaint should bespeak our interest in decency and fairness. And isn't that not only the right of every citizen, but isn't our ideas about democracy, including decency and fairness for everyone, mean that we want that society no matter who brings the complaint? I think we do. And I think this is the wrong approach to take. In fact, what we want is decency and fairness to be the most accessible, not the least accessible. And I think it's very significant that that's the lesson you have sent out, apparently deliberately, according to this recording. Thank you.
Mr. Chair, point of personal privilege.
Yes, Commissioner Keene.
Since I was referenced by the speaker relating to those comments, and those were comments that I did make, I did not make those comments with any degree of pride. I made those comments with a tremendous amount of admiration for the gentleman who had indeed persevered through a bureaucratic, Kafkaesque nightmare in order to get his complaint heard. But I certainly wasn't saying that that process was in any way desirable. I was saying just the opposite. The process was shameful, and I agree with you in terms of what you were saying. And the idea of it having taken that long and him having to go through all of those hoops is something that I and my colleagues, I'm sure, took quite a lesson from. I haven't been on this commission very long, but I'm sure that we all took quite a lesson from it. You make an excellent point. I think he made great points. And those comments of mine praising him echoed your comments. It was not my being laudatory of the process. It was just the opposite.
The next item on the agenda is discussion and possible action on matters submitted under Chapter 2 of the Ethics.
I'd like to make public comment, please.
Please.
I'm Peter Warfield, Executive Director of Library Users Association. About 10 years ago, I brought a complaint to the Sunshine Ordinance, which was successfully pursued and ultimately went to the Ethics Commission. That complaint was, I believe, the first in a series of complaints that Alan Grossman brought to the attention of at a much later time, and was included in the civil grand jury's report calling this body, the Ethics Commission, a sleeping watchdog. That was the title of the grand jury's report. Now, I did want to say something with regard to following up on something that I don't know if you're aware of or not, but shortly after that report came out, the Sleeping Watchdog report, lo and behold, the Sunshine Ordinance Task Force found yet another violation that they sent to the Ethics Commission. That one concerned the president of the Library Commission, the then president, Jewel Gomez, who had shouted down a member of the public when she tried to speak at a Library Commission meeting. You took this matter up and found, in words that I'm not exactly able to quote, since she wasn't an elected official or a department head, you said you didn't have the power to basically unseat her, but you sent a letter to the mayor saying that her behavior was basically outrageous and fell below any standard of decency and public service that should apply, and recommended that she be sacked. That letter got no response whatsoever from the mayor. And after a year, I believe a number of what loosely is known as Sunshine Posse folks came to remind you, and you ended up then sending a second letter a year or more later, reminding the mayor of the first and asking him to take action. That letter also was never responded to. Eventually, and I'm a little uncertain about the timelines, and I'm sure that somebody else who's here could tell you, eventually, a year ago, the mayor did not reappoint Jewel Gomez, the president of the Library Commission, who we had reappointed in the meantime and who had been reelected president. He also did not reappoint Vice President Lee Munson, and so in March, they ceased to serve on the Library Commission and haven't basically been heard from again at the Library Commission. Thanks.
The next item on the agenda is discussion and possible action on matters submitted under Chapter 2 of the Ethics Commission's regulations for violations of the Sunshine Ordinance. Under Chapter 2, the respondent bears the burden. The respondent should therefore please feel free to come and make their presentation. This matter relates to Ethics Complaint 01-140107.
Good evening, Commissioners. John St. Croix, the Director of the Commission. I just have a few points that I'd like to make here, in addition to what I've already submitted to all of you.
Just to be clear, Mr. St. Croix, you have 5 minutes.
Okay. Commissioners, because this case is being considered under a Chapter 2 referral from the Sunshine Ordinance Task Force, staff did not conduct an investigation and is not making a recommendation in this case. Mr. Grossman's argument about a conflict of interest lacks validity. The Commission staff has absolutely no record of Mr. Grossman filing a complaint on this issue directly with the Commission. The notion that the Commission by virtue of its bylaws, has pre-waived all attorney-client privileges, has no weight. The bylaws require the Commission to adhere to the Charter, and the Court of Appeal made clear that the Charter trumps the Sunshine Ordinance. In terms of waiver of the attorney-client privilege, the withheld communications were between me and my staff and the City Attorney's Office. None of these communications were with members of the Commission. As such, I in no way usurp the Commission's legal responsibilities. Because none of these communications were with the Commission members, if a decision about a waiver were to have been made, it would have been my decision to make. Mr. Grossman, in spite of the clear ruling of the courts, continues to insist that the documents were disclosable. They were not. The Charter was clear then and is clear now. The Court of Appeal has affirmed this. The Supreme Court refused to hear an appeal. This issue has been exhausted. Mr. Grossman continues to demand that the city use resources on a case that the courts have decisively ruled upon, and the issue should come to a close, and I very respectfully ask that you find that there was no violation. Thank you.
Questions for Mr. St. Croix? I have a couple questions, Mr. St. Croix. Mr. Grossman, in his statement, says that you went to the task force and said that you did not know how many records were withheld, how many pages were in those records, and that you had never read them.
That's what I said at the time, yes.
Why didn't you, before going to the task force, determine what the records were, and how did you withhold them if you didn't know what they were?
Well, the staff reviewed all the documents. There were a number of them, and then in camera with the city attorney determined which ones were not disclosable. When
did that happen?
Shortly after the request for the documents was made.
Who on the staff reviewed the documents?
Catherine, and again the city attorney.
Who was this? Which city attorney?
Andrew Shan, I believe.
When did you become aware of what was withheld?
At the time that we sent the response to the disclosure request.
When was that, approximately?
I believe we sought an extension, so probably a couple of weeks.
A couple of weeks. What does that mean?
After the request was made, within I think 14 days.
But by June 5th, 2013, you didn't know what was withheld, or hadn't read them? I'm sorry,
No.
I'm confused by the timeline.
No, I didn't read the documents. I accepted the recommendation of the staff and the city attorney.
But at some point, you read the documents and reviewed them, right?
Much later.
And when was that?
After, I think when the original lawsuit was filed.
Okay. I don't have any further questions. Mr. Grossman? Thank you, Mr. St. Croix.
I know the Commission has started the hearing, but I thought perhaps you would address the point I made about your conflict, which is so obvious and so apparent that the fact that I come second, it seems that it's being heard through me. The Commission cannot hear this matter because of its obvious conflicts of interest, which I set out in my memorandum. Mr. St. Croix recognized that a year and a half ago because he had proposed at a meeting that you amend the regulations to exclude the Commission, himself, and the staff from the Sunshine regulations that are the basis for this hearing. And he did it to avoid the appearance of any possible conflict. You declined to adopt his proposal. Obviously, appropriate to do that. In any case, at the end of the discussion at the meeting, Commissioner Herr suggested that the commissioners would be able to recuse themselves if there was a conflict, and then the matter would not be adjudicated by the Commission. In any case, the conflict is even more dramatic because under the Charter, the Commission is responsible for everything Mr. St. Croix does, period. So in effect, when you hear this, you're adjudicating or judging your own actions, which seems to me to be a pretty low standard in order to move the hearing along. Anyway, there are a couple of issues involved here, and I couldn't hear Mr. St. Croix well enough, but there was the issue of the waiver that I raised in the memorandum, because in my view, of course, I'm a lawyer of only 60-plus years' experience. I think that that bylaw constitutes the waiver, as does the one where the Commission agrees to enforce the open government laws, which is precisely what's involved here. In any case, Mr. St. Croix believes this is a single-issue case. Again, in my memorandum, it's clear that there were 3 violations involved in the order, not just the question of the attorney-client privilege exemption and its applicability. That task force order regarding those 2 other violations remains to be enforced. And that's, if you go ahead, despite your conflict, and hear it, that's what you would be addressing. But I think I have a larger point to make, and it's this. The adverse effects of the litigation and the Commission's 10-year history under Mr. St. Croix's aegis of failing to enforce task force referrals creates a serious problem for the Commission and its constituency, the public. The trust given to the Commission to support and enforce public access in San Francisco is broken. And the Commission has de facto ceded the decision power in the public access area to Mr. St. Croix, whose blatant hostility to public access is documented and well known to those of us who are interested in open government. His disrespect of the task force members was palpable in his appearances before them. Mr. Pilpel, who has been before you several times and is a task force member, was begging Mr. St. Croix, tell us more about these records. What kind are they? How many are there? Okay. With an important provision of the ordinance now unenforceable, other provisions in the ordinance will be negatively impacted, and I can give you at least 1 or 2. And that further erodes open government and the Commission's mission. I believe the Commission has to ask itself whether this new reality is what it wants as the sole policy body with the enforcement power under the ordinance. I'll go over the 5 minutes, about 20 seconds. In any event, the Commission must decide to either repudiate the executive director's actions and take steps to restore the enforceability of the affected provision, or amend its 2 bylaws to reflect the fact that it will no longer enforce the ordinance or actively enforce all ethics laws and rules, including open government laws. In sum, at a cost of $150,000 to the taxpayers, Mr. Croix, with the connivance of the city attorney, went off on a frolic of his own and left the mess that you now need to fix. Thank you.
Any questions for Mr. Grossman?
Yeah, I have a question. Mr. Grossman, how can you argue that somehow or other Mr. St. Clair violated the open government ordinances when the court specifically ruled against you on that question?
I'm conceding that the privilege is no longer, the abrogation of the privilege in the public access area under the ordinance is no longer enforceable. End of story. Okay. But there are other provisions in the ordinance that he violated.
What are those provisions? Tell me.
What are they?
Yeah, tell me what they are.
Well, one is you have to identify the records in some way. Were they emails? Were there memos? Was there an opinion? You have to do that.
But the court reviewed them.
Sir, if I can interrupt you, when I filed the lawsuit, the first thing that the city attorney did was turn over 4 of the 28 withheld records.
Right.
Okay? So it's not a case where this was, open and closed and just the way it was reviewed by the Court of Appeal on one issue. But there are 2 other issues. There are 2 other provisions of the ordinance that are cited in the task force order. Those are the ones that are involved. But if I'm going to make myself probably look, I'm having trouble with words. I think it's age and other. But if I try to make a case to you about these 2 other violations, it runs contrary to my argument that you shouldn't even be hearing this case. Why are you hearing it?
So, Mr. Grossman, on the point you've just raised, I am looking at the decision in order of determination, and it finds the violation for failure to release the records. So I like the Vice Chair, have also had a hard time figuring out what other violations you think the Sunshine Ordinance found, because looking at the decision in order, I don't see anything else. I certainly don't want to make you provide a new argument.
Do you have the order of the task force in front of you?
I do.
And the referral?
We do have the referral as well. But, I mean, if your argument is that,
It's the fact. There are 3 violations in the referral, I'm pretty sure.
Can you point us to it?
Was only 1 of the 3.
Can you point us to it? Because that is an issue I was certainly struggling with.
Okay, I can do that. Okay. At its September 4 task force meeting, the task force found John St. Croix in violation of the Sunshine and voted to refer the complaint to the Board of Supervisors and the Ethics Commission for violating sections 6721B, 6727A and B, and 6724B1I and III. And III is the privilege provision.
What is the date of the document you're looking at?
I'm reading from my memorandum, which you each got. It's on page 4 at the top.
Right, I have your memorandum, but I'd like to actually see the... Staff, do you know where this is in the packet?
This is on. Chair Herr, I believe it's right before the order of determination in the letter. It's on the second page. There's not a page number here, but it's on the second page, first full paragraph.
November 21st, 2013?
No, that's the date of the letter, and then on the second page, first full paragraph at the September 4th, 2013 meeting.
Any other questions for Mr. Grossman? Thank you, Mr. Grossman. Thank you. Rebuttal?
I'm not finished. Oh, I'm sorry. I am finished.
You are. Well, you
no
said
more
you were.
questions.
I'll be very brief, Commissioners, and I'd just like to note for the record that I really don't appreciate the personal comments leveled at me. It just happens all too often. And I believe that the order of determination and the referral letter are conflicting. 67.27, Mr. Grossman wanted an enumerated list of what was in the documents and how many there were. This is also called a privilege log. Under the Sunshine Ordinance, privilege logs are not required in 67.27. You don't have to create documents that don't exist to answer requests. 67.24 is about pre-litigation claims, and no pre-litigation claims existed in this case. That's all I have to say. Thank you.
Any other questions for Mr. St. Croix? Public comment?
Yes, thank you very much. I'm gratified that you recognize the Kafkaesque obstacles that we face. I have not gotten the impression that you recognized that in the past. It's gratifying now. I appeared before you on September 23rd, 2013, and brought Mr. Grossman's lawsuit to your attention. The important issues and the necessity for you to look into it. You made no response to me. Do you categorically ignore statements from the pro-democracy rabble? Do you assume that if the pro-democracy rabble is complaining about Mr. St. Croix, that means he's doing something right? What's crucial is not only did the city attorney turn over records after Mr. Grossman filed the lawsuit, but at the time Mr. Grossman filed the lawsuit, the response that Mr. St. Croix had offered, instead of the ones that were offered to the appellate court, was, and I quote, "You have already received all documents responsive to your request. We are not required to create documents that do not exist. I consider this matter closed." Now, if you look at the issues that should have been responded to with respect to Mr. Grossman's complaint, we don't have to create documents is the Sunshine equivalent of go jump in the lake. Do you know who Primo Levi is? Primo Levi spent about a year in Auschwitz. He tells the story of he's walking under an eave one day. They're not only starving to death, but dying of thirst. He pulls an icicle off an eave and sticks it in his mouth. He gets the butt of a rifle from the Nazi guard. Primo Levi turns to the Nazi guard and says, "Warum? Why?" And the prison guard says, "Here is kein Warum." Isn't that what Mr. St. Croix has said to me? Isn't that what Mr. St. Croix has said to Mr. Grossman? I don't speak for Mr. Grossman, but if the defenses that had been offered to the appellate court had been offered to him, he might have made a different decision. But more important than that is that everybody is entitled to a reason. Primo Levi doesn't call it anti-democracy. He calls it anti-humanity, because we're all entitled to reason. It's the field of reason that we all cross which creates the bond of humanity. And that's what's really at stake here. Look at this case again.
I'm Peter Warfield, Executive Director of Library Users Association. I'm not a party to this case, but certainly recognize, as the previous speaker has mentioned, the significance of, as do many people, the importance of open government and the good functioning of open government law. I think there are many conflicts here that are very problematic. Some of them have already been mentioned. The basic hearing by your body of your director, I understand that there was that Commissioner Hayon gave an okay to an extension at one point with no commission action involved. And of course, there's the whole question of whether the commission ever took a decision to pursue the case in the first place. Mr. Grossman very clearly stated in his memo to you, dated, and it's on page 4, repeating some of what you've said. It's a January 15th memo that he provided to you in your current agenda packet. And on the top of page 4, he quotes from the Sunshine. He quotes, at the September 4, 2013 Sunshine Task Force meeting, the task force found John St. Croix in violation of the Sunshine Ordinance and voted to refer the complaint to the Board of Supervisors and the Ethics Commission for violating Section 67.21b, that's number 1, 67.27a and b, that's number 2, and 67.24b, 1i, and III, that's 3. And then he goes on page 4 with a detailed description of what those laws say and what specifically was Mr. St. Croix's failure with respect to those laws. And he's presumably quoting the Sunshine referral. So that's something that is in not just an old document, it's right in your agenda packet right now. Mr. St. Croix comes up with unfortunate, to me, puzzling chestnut. You don't have to create documents that do not exist. Certainly you do. If there's an immediate disclosure request, you have to answer it. If there is a notation required on records as to why they were withheld, that's creating a document. There are other sections of the Sunshine Task Force requiring, for example, what I call info on info. If I want to know what is the nature and extent of your documents on such and such a subject because I don't know what they are and I want to focus my request, the department or agency is required to present under Section 67.21 an explanation. So it's not the case you don't have to create documents that don't exist. But in this case, the law hasn't been followed as required and as laid out in Mr. Grossman's memo to you on this agenda item. Thanks.
Commissioner, so I think a couple issues to address. One would be the alleged conflict of interest, and then to the merits. I do have some questions for the city attorney, but I want to open it up to my fellow commissioners to the extent there are any comments to begin the discussion.
I'm also interested in the conflict of interest question.
So wanted to raise with the city attorney, what is the city attorney's view on this assertion that there is a conflict of interest in the commission adjudicating this matter?
The city attorney does not think there's a conflict of interest here. This is not the functional equivalent of the commission reviewing its own action. Here it's reviewing the action that the staff took with respect to the decision of whether to turn over the documents. This has the commission wasn't consulted, nor did the commission have to be consulted, since this was exclusively a decision by the staff under the charter. The staff has the authority to conduct its own day-to-day affairs, which includes responding to Sunshine requests. That's what it did in connection with the city attorney. So there's really no. I just don't see how this is sort of the functional equivalent of the commission reviewing itself. And in any event, even if I think even if there was a conflict, the solution is not that this ethics commission can't hear the complaint. I mean, there have been circumstances in the past where the commission has referred out the investigation of a particular matter to another municipal entity to conduct and then present, but there's not a circumstance in which the commission could recuse itself from adjudicating this type of complaint.
Could I follow up on
Yes,
that?
please, Commissioner King.
You talked about the power and the authority of the staff to go ahead and take certain actions. In your opinion, does the staff have the authority without informing or getting the permission of the board to go ahead and institute litigation?
Well, yes.
They do.
Are you referring to the facts of this case where the writ petition was filed, the court found in favor, the trial court found in favor of Mr. Grossman, and then the appeal was taken by the commission by Mr. St. Croix?
Well, let's go back further. The original litigation itself, to enter into that litigation and to actually defend against Mr. Grossman's assertions that the materials didn't have to be turned over. Can the staff independently make that kind of determination, go forward, litigate, without at least informing the board, or two, at least, or beyond that, getting the permission of the board? Aren't there policy matters and things in regard that are involved in that?
There's no obligation that I'm aware of to seek the commission's approval before defending itself in litigation. The decision here, the decision.
Can I just interrupt you? You said defending itself in litigation.
Defending the commission.
Is the staff some sort of independent, autonomous body aside from the Ethics Commission, that it would have standing to do things as a person in litigation?
Well, here Mr. St. Croix was named as the respondent. And in fact, when the task force referred the matter to the Ethics Commission, it was only Mr. St. Croix who was named as a respondent, and that's because the decision of whether to turn over the documents was Mr. St. Croix's. Of course, the Ethics Commission, the body of which you're a part, oversees the staff and can set policies, but the commission has the authority to conduct its day-to-day operations. And I think part of that is, as here, if Mr. St. Croix is sued, I think he can defend himself without having to seek the opinion or seek the approval of the overseeing commission.
You think it was a good idea that Mr. St. Croix did not at least inform the commission and seek the approval of the commission before starting and getting involved in such a major piece of litigation? Aside from anything that might be your opinion relating to whether or not he could do this independently, and that the staff has some sort of independent power to do these things, do you think it might have been a good idea if he told us that this was going on and perhaps sought our permission to do this?
I'm happy to provide legal advice to the commission, but I would defer to you as to what, beyond strict legal questions, what is or is not a good idea. I think that's a call that I'm not qualified to make.
Okay, thank you.
Any other comments from the commissioners?
I'm just mortified that the city attorney never heard of the Brown Act. And the Brown Act governs actions taken by the commission. And the only way that the commission can act is at a public meeting. And at the public meeting, there is public comment. So when Mr. St. Croix decided not to disclose and not tell you about the fact that you could waive the privilege, when he defended the lawsuit, when he actually lost in the Superior Court and he initiated a mandamus case in the Court of Appeal, weren't those actions by the commission? After all, who's he acting for? And that's clear under the charter. So to my mind, this advice that you just got is so typical of the city attorney's office. They were waiting for this kind of case so that they could assert what they've been talking about for years, which is that section of the Sunshine Ordinance had to be dealt with.
Thank you, Mr. Grossman.
Commissioner, can I just add one quick thing?
Yes.
Mr. Grossman raised this precise argument before the Court of Appeal, and it was rejected.
I know. So a couple thoughts that I have, and I'll again open it up to the floor. I do not see a conflict here personally. I understand that there is perhaps the appearance of a conflict, but I don't think there's a legal conflict. I also know that we've had a hard time having matters like this adjudicated by another body besides ourselves. So I think we should get to the merits. On the merits, looking at the 3 violations that were identified, Mr. Grossman is correct, in the referral letter, although not included in the order. They seem to refer to the failure to identify the provision that applies, which seems to me to be contradicted by Mr. Massey's email where he identifies the provisions. In addition, I agree that this was not a pre-litigation matter and that the documents that were withheld were adjudicated by the Court of Appeal, and it was not found in Mr. Grossman's favor. In particular, the Court of Appeal did deal with this issue of the Commission not authorizing the lawsuit, and while I concur to some extent with Mr. Keene that perhaps as a policy matter that may be a different story, as a legal matter, I think it was allowable. Those are my views. I'm happy to have further discussion from the commissioners on the issue, on any of the issues. Is there a motion on this matter?
I make a motion that we find that there is not a basis for finding that the executive director violated his obligations under this on an appeal from the Sunshine Ordinance Task Force, and that we're bound by the finding of the Court of Appeals that his actions were consistent with San Francisco open government ordinances.
Is there a second?
Second.
All in favor? Aye.
Aye.
Opposed? Hearing none, that motion passes. The next item on the agenda is discussion and possible action regarding approval of proposed amendments to CFRO. Mr. Minardi, I understand you're going to be helping us lead the charge here.
Mr. Chair, may I?
Oh, yes.
I move we continue this matter to our next meeting. We're on, this is item 4, isn't it?
Yes.
I move we continue this to our next meeting, mainly because of the nature of all of the materials and that there's just so much substance involved here. We've got, this is what we've got. We've got 4 inches of materials, much of which deal with very important changes and adjustments to San Francisco campaign finance ordinances, which will go to the whole heart of the transparency and honesty of city government for a long period of time. We've received requests for it to be continued by some really regarded entities such as the Friends of Ethics. I've looked over the materials that were amassed in the public comment meetings, which Mr. Minardi, I have to say, handled quite well. He did an excellent job in regard to his comments in regard to that. But there's just so much here. I have to say, quite honestly, I have not digested it in light of all of the materials and all of the other recommendations that are there. And I don't think we're under any kind of pressing aspect. The next thing that where this is all going to fall is going to fall in the upcoming election, which is an important election. We have a mayor's election, district attorney's election. So we got this just a week and a half ago or so. We're in the pretty much in the at the end, at the beginning of the year, the holiday season. I would respectfully ask my colleagues to let us take a little more time on this, and that it go over to the next meeting.
I certainly understand that it is dense and there's a lot here. My concern with holding it over is that there are people here who are here for this agenda item, and I know the staff has put in a lot of time, and if we want to get it for it to be finalized for the fall, I think is a process that would require a fair bit of time. But I'd also say that we don't have to make decisions today if we determine that we need more time after going through it. But I do think it would be useful, given who's shown up and the preparation for the meeting, for us to at least address the agenda item. Commissioner Han?
I would just like to add that while I agree that we can continue any final decision that we might come to, it is always very helpful to me to hear the expert and learned comment from those interested parties that have something to add. I think the letters we received were very interesting and very helpful and enlightening, and I'd like to hear from the people who are here at least, even if we aren't ready to make a decision in these matters.
Other comments from the commissioners? Commissioner Keene, would that be acceptable to you?
I think in terms of the spirit of what Commissioner Han is saying and also what the chair is saying, I'd like to propose a sort of split the baby type situation, that we're going to look at this as something that's going to be something of a bifurcated proceeding, that we go ahead with what we have. And also table it, and also put it on for the next meeting as well, for anything further that might be added, and also for final decisions. I think that should take care of the concerns that are raised about having people here now be able to speak to it, which I respect.
Okay. Any?
I would like to hear from the people who are here, their comments on it, and at the conclusion of that, then we can take up the question whether we ought to defer a final decision, given their comments.
That sounds perfectly reasonable to me.
And could I also add to Commissioner Rennie's understanding of what we'll be doing, that we'll also, in deferring a final decision, we can also take up additional analysis as well at the next time.
Sure, yeah. I mean, we can put anything else on the agenda for February.
That's fine. I think that takes care of my concerns.
Okay. So, Mr. Minardi, without any further ado, if you could introduce the item, sure. And before you do that, I'd like to thank you and the staff for your efforts. I mean, I know the impetus here was to provide some streamlined regulations to help improve CFRO, and we will probably have a debate about which of them accomplished that goal, but I certainly applaud the effort and know that it's not an easy task.
Thank you, Chair. Jesse Minardi, Deputy Director. So, Commissioners, what I propose I do is just sort of generally introduce the matter, kind of give you a sense overall of what kind of initiated this, the rationale for it, and then if it's okay with you, I can walk through very generally sort of the three, what I see as the three primary components of what we have here, and then it might be appropriate at that point for.
I would like for you to do it one at a time. So let's
sure.
take the first one. Why don't
sure.
you introduce it, and then let's hear some public comment on it, and then we can go to the next two.
That's great.
Sound reasonable to the commissioners?
Should there be public comment on the suggestion that the matter be deferred?
We haven't decided that it's been deferred.
You have decided that it's not going to be deferred because you started a conversation.
Pardon me?
You've decided that it will not be deferred. If you start a conversation, you can start hearing the item.
No, it's an agendized item, and we are addressing it.
We have no chance to comment on the fact that it's on the agenda at all until we take up item by item? It seems to me that there is a larger issue than going through item by item.
Mr. Bush, you can make your comments during public comment. So, Mr. Minardi, if you could start with number 1.
Sure. Well, maybe I'll just take just a second to give you background. So these amendments to CFRO were prepared primarily because they, in staff's opinion, are sort of common sense, technical, granted very technical, but common sense sort of changes that are kind of a long time coming with respect to CFRO and the complexity that's inherent in the reporting, the disclaimer requirements, but also, frankly, the limits, which have been either declared unconstitutional or are likely to be declared unconstitutional by a court. With respect to the disclaimer and the reporting requirements, although common sense and I think fair with respect to all political actors involved, again, technical, common sense, but also significant, because really what staff is trying to do here is sort of lower the barrier to entry for third parties that want to be involved in politics in the city and county of San Francisco. As the memo hopefully is clear about, there's a lot of complexity, confusion, even within CFRO itself. So the effort here was to offer something that would be hopefully fairly uncontroversial in that it would affect all parties the same way and would then be ready for the 2015 election. I would contrast that with something like, say, limits or prohibitions, where it would appear to me that the initial, it's sort of a multi-step process there where we're talking about things like, is it a right policy decision? Is it factually justified? Is it legally okay? And then finally, whether the language is okay. So that is what motivated this. Now, there are the 3 issues. One, as I said, the limits. Second is the third-party reporting requirements. And third is the disclaimer requirements. And with respect to the first, this is hopefully the most straightforward for everyone. There are essentially 2 provisions that, by virtue of case law, this commission is just no longer enforcing. And for the sake of clarity and at the commission's direction, we've just proposed repeal of those 2 provisions. One is an aggregate limit that's comparable to the federal aggregate limit that was struck down in the McCutcheon case earlier this year. And the second is actually, I'm sorry, I have it reversed. The second is the aggregate limit. The first is the limit on contributions to third-party PACs that are making expenditures with respect to city elections. And because they're either have been struck down or likely to be struck down, we're just proposing, per the Commission's recommendation itself, that we just repeal those provisions.
So 1.11482 is the one based on McCutcheon that has essentially been struck down.
Oh, you're right. I'm sorry, I misspoke. Yes, that's correct. That was the McCutcheon provision.
And 1.114C is the one relating to PACs that hasn't been expressly stricken, but
well, it has been. It's been enjoined. The city's been enjoined from enforcing.
The city's been enjoined by a district court.
Yes, that's
but
correct.
Where is that in the appellate process, if anything, if at all?
I don't think.
Yeah. So as we settled with the plaintiffs quite a while ago, and the matter has not been appealed.
Matter has not been appealed. Okay. Public comment.
Thank you. I'm Larry Bush on behalf of Friends of Ethics. Friends of Ethics consists of a dozen people who are very active on behalf of ethics issues, including 5 former commissioners of this body, former staffer in charge of fines, the past head of Common Cause for San Francisco, and others who have been involved in passing legislation. We had several points that we raised in the interested persons meeting. We think that Mr. Minardi did an excellent job of summarizing the points as we went through the things. We appreciate that effort because it really is a standout compared to what we have seen in the past. So I'd like to, on behalf of Friends of Ethics, extend our appreciation on that part. One of the issues that we raised repeatedly was that this was so narrowly drawn that it didn't encompass the issues that are on the table that need to be dealt with in this coming election out of the campaign law. And as part of that question is that this body never had a public hearing to discuss the fact that you're going to take up this issue and allow the public to comment on whether or not there should be a broader review of the issues that are involved in any changes to the campaign finance reform. We sent you a memo. Included in the memo were a list of issues that the Commission itself had already passed, that you asked to be put into the law, none of which are showing up in this draft. Some of those recommendations from the Commission are 2 years old, and they still have not been put into the law or proposed to you in this revolve. Now, considering that you already held those issues, had full discussion on them, asked the staff to draft them, no draft came back, and it's not in this, I think that that's one of the reasons why we said this needs to be held over for a fuller discussion of all the issues. I would recommend that you have someone go through, as we did, the last 2 years of minutes and pull out all the times when the Commission asked for legislation to be drafted dealing with this law and which are not included. Secondly, we are going into an election season where it matters a great deal as to whether or not we are building public trust. I've discussed this, and we discussed it in our interested persons meeting. An example is we allow elected officials to have a general purpose committee, which is not a candidate committee. And a general purpose committee can accept contributions of any amount from any source, whereas a candidate cannot. And what we have seen is we have an elected official who does do that, who has accepted contributions over $25,000 from people who have business before the city and who are being decided by that official. That will not be touched in this at all. It would be easy to, at a minimum, put in a provision that says that the same restrictions that apply to candidate committees would apply to committees that are controlled by a candidate or an office holder, because you have to deal with public perception of honesty. Thank you.
Thank you.
Good evening, Commissioners. Anita Mayo, Pillsbury, Winthrop, Shaw, Pittman. Just very briefly, I'd like to applaud staff's efforts to clean up the contribution limits that Mr. Minardi just reviewed with you. They now conform, San Francisco's campaign law with respect to limits at least now conforms with prevailing case law that's been imposed by the U.S. Supreme Court and the Federal District Court here in the Ninth Circuit. Thank you.
So I'm happy to hear from other commissioners on this particular one. I mean, to me, this one seems pretty clear. If we think we need to defer it to another meeting, I'm happy to consider this with other issues, but I also don't want to have to revisit things that we've already addressed. To Mr. Bush's point, I also don't think that we have to deal with all CFRO changes in one meeting. There are other CFRO changes that we can address. I do think Mr. Bush raises a good point that if there are things that we haven't addressed that we should be, let's take those up too. But I don't know that we should hold up all proposed changes because it doesn't include everything we'd want to change in CFRO. But I open it up to my fellow commissioners.
Well, I'm prepared to move that we, on decision point 1, that we approve the proposed repeal of CFRO sections 1.114A, A2, and 1.114C as set forth in the in Appendix A.
Commissioner Keene?
I'll second that. This is something we have indeed discussed, and on those two specific aspects, the Supreme Court of the United States has been rather definitive that that's something that we cannot indeed enforce. And we did vote a few months ago exactly the way Commissioner Rennie is proposing in regard to this. We all voted unanimously that that's not within our power. So on those, I don't have any problem with it, and I think it's just redundant. I'd second Commissioner Rennie's motion.
Any other comments from the commissioners before we take a vote on that? All in favor?
Aye.
Aye.
Opposed? Hearing none, that motion passes. Mr. Minardi, can you introduce the next issue?
Thank you, Chair. So the second set of amendments is with respect to reporting requirements for third parties who are involved in supporting or opposing candidates for city elections. And the city has instituted through CFRO a number of reporting requirements over the years, which are really designed primarily for two things. One is general disclosure to the public, so that the public can fairly judge messages, so that there is transparency with respect to political actors, but then also so that the voluntary and the individual expenditure ceilings, we can monitor them and raise them if necessary. With independent expenditure ceilings, if there's a certain amount of spending, those ceilings, which are sort of put in place when people accept public financing, they can be raised. So the reporting requirements are really put in place for those two purposes. And what has happened over the years is that a number of these requirements overlap with each other, but also overlap with state law. And a few years ago, an important thing happened in state law, which is that within the 90 days prior to an election, any outside group, which can be an individual, can be a PAC, can be a trade association, whoever it is, anybody who's making independent expenditures, saying vote for or vote against these particular candidates, has to file a report with the Ethics Commission disclosing that spending. So, the vast majority of all spending in elections happens after Labor Day, so certainly within the 90 days. And what's happening is that, particularly with mailings, the overlap is significant. And I know, having been in the compliance sector for a while, it's very confusing. And the example we give is of a mass mailing that if you do a mass mailing of, let's say, $5,000, which is what one of these things will cost, you have numerous state and local filing requirements that you have to worry about complying with. And of course, with respect to sophisticated parties, or at least parties that have money, that compliance usually is what happens. What we see, though, is that the less sophisticated parties, the parties with less money, often run afoul of the law, and we end up it ends up as a discouragement, really, for these groups. So in the effort of sort of streamlining, simplifying, and in a way that will benefit all who are involved in the political process, we have proposed basically having three requirements. And it's in Appendix C is really the summary in sort of chart form of what we're proposing to do, and the first chart sort of indicates what are the applicable filing requirements both for state law and local law. And you'll see that there are various thresholds, there are different thresholds, there are different due dates, different forms. And what we've proposed doing is essentially breaking up reporting requirements according to the type of communication, and there are basically three: independent expenditures, saying vote for or vote against a candidate with the so-called magic words. And we propose adopting the state standard of $1,000 spent per candidate, due within 24 hours. And what we would propose augmenting the state requirement is requiring a copy of the actual expenditure to be filed with us, sort of the same way it is now. Then we have electioneering communication. We propose shortening the due date to 24 hours, but clarifying that it's $1,000 per candidate. And this is, among other things, an attempt to get to ballot measure communications, which, certainly a ballot measure communication where there's a candidate and his or her face is sort of huge on the mailer, we think qualifies as electioneering communication that should be reported. But as most people will tell you, there's a lot of ballot measure communications where there's a long list of tiny little names where they say these people have endorsed. Technically, under our law, that's an electioneering communication, has to be filed, has to comply with the disclaimer requirements. We propose having the same threshold as at the state level, $1,000 per candidate of spending. We think that will bring in the significant electioneering communication where, say, a candidate is clearly benefiting from a mailer or an advertisement with respect to a ballot measure. And then finally, member communications. Again, these are reported currently primarily with respect to the expenditure ceilings, and we would propose actually lowering the threshold instead of $5,000 per candidate within 24 hours to $1,000 per candidate in 24 hours. With all of these, we would require a copy be filed with us so that we would have that particularly helpful with respect to enforcement efforts. There are some other things that we go into in the memo in more detail, and I do appreciate it. There was a lot there. But that, I think, sort of sums up as a general matter what we were trying to do with this section.
Can I ask you before I open it up to public comment, which of these from pages 7 through 10 did the commission receive the most negative feedback on?
That's a good question. Well, I think
specifically looking at sub D in the
right
enumerated.
Well, I think I could tell you, there are really, I would say, well, I could tell you the 4 sort of criticisms that we got from the Friend of Ethics with respect to this, which is probably the most representative. One is that, and this is in the memo, and Mr. Bush can certainly. I don't want to mischaracterize what Mr. Bush says, so I'll explain what I think it is, and he can correct me if I'm wrong. One is electioneering communications, which are defined as communications which reference a candidate, 500 or more within a 90-day period of an election. There's a suggestion made that at the interested persons meetings that 501c3 fundraising event invitations be exempted because often what will happen is there will be fundraising events where a keynote speaker will also be a public official. And there are other examples of that, like debates by nonprofits, et cetera, where we've exempted them from electioneering communications. And because 501c, certainly there are nonprofits which can and do advocate with respect to elections, but because 501c3s are, by virtue of tax law, just absolutely prohibited from advocating one way or the other way with respect to a candidate, we thought it was reasonable to put it in. Electioneering communications, there's a request that vendor information be included within 24 hours. And again, we responded to that in our summary memo. Similarly, member communications, there's a request for donor information, which does not exist currently, and which we believe would present significant reporting challenges for the main sources of member communications, which are labor unions, which already basically identify who they are. And by the way, member communications cannot be funded.
Could you explain that?
Sure. So member communications right now are...
the challenges. What would the challenges be?
Oh, for the member communication?
If they had
sure.
to do that. Yeah.
Sure. Yeah, definitely. So with a member communications have to be funded by the members themselves. So you can't have, if it's truly a member communication, you can't have a third party come in, pay, say, here's $10,000. Please spend this to go, spend this on mailers or whatever it is sending to your members. It has to be funded by the membership funds themselves. And I know myself, I've been involved in instances with labor unions where, over the course of they've had to try to determine in other contexts, well, how much money is attributable to each, they take out $75 from your membership, in membership dues every month, or let's say twice a month. And so you take the value of a mailer that went out, that's $10,000, $5,000, again, all internal, and you then have to attribute it over the course of the entire year to each one of these individual members who may not have affirmatively said, I want to send this mailer, but at one point or other may ultimately, because of sort of the accounting of it over the course of a year or a year and a half, reach up to that $100 disclosure threshold. And so there, with the exception of political parties and their member communications, there's no jurisdiction that I'm aware of at the federal level, state level, that requires this disclosure of membership donations for member communications, probably given sort of I would imagine, the right of association. And ultimately, in our experience, it's mostly labor unions. And so most of the time, you're going to know maybe not the individual who reached that $100 threshold, but you're going to know sort of the people who are the players who are actually sending out the mail. So I hope that makes sense.
Yeah, it does. Thank you.
Yes.
Thank you. Should we open it up to public comment? Let's do that.
I don't think that Mr. Minardi mischaracterized anything, but we do have a different point of view than he has. In terms, let me make sure I am reciting the right items. The first one that we talked about was
the nonprofit fundraisers.
Nonprofit fundraisers. So you have nonprofits who are able to be involved in ballot campaigns. They cannot be involved in candidate campaigns, but they can certainly be involved in ballot campaigns. And they can be involved in a ballot campaign where someone is running for office and was one of the authors and sponsors of the ballot measure. So let's say you have a ballot measure dealing with city park funding, and you have one of the authors of the bond measure who comes and speaks at Friends of Rec and Park or some other nonprofit on the eve of the election about how important it is to pass that measure. And that person happens to also be on the ballot. That's why we said that there should not be an exemption for a 501c3, because they are involved in campaigns that have a spillover onto candidates. We'd ask you to consider that. And if you want us to run through actual examples, I'd like to do so with my attorney present, so I don't smear anybody. In terms of the member communications, it really comes down to how you define a member. And that's been an issue before this commission for more than 10 years. As Mr. Minardi says, there is a rule that doesn't view political parties as having a member type of communication, because that came up once before when the California State Democratic Party flooded Los Angeles in a campaign with money from the state, but it was a, quote, member communication to all the Democrats in Los Angeles. So they cherry-picked where it was going. The same thing happens here in San Francisco from groups that have a special interest. And we don't really know who the members are. Does anybody know who the members are of BOMA, the Building Owners and Managers Association? Are they people who are also giving money to candidates directly, and then in addition to that, giving money through BOMA, and thus hitting a very large threshold that the public doesn't see? We don't know. How about SF City, the new nonprofit that's been started by Ron Conway and made up of high-tech nonprofits, high-tech businesses? They're politically active, and they're lobbyists. So how do we know what? That's why we want disclosure of donors to those groups. because they are politically active. I would just make one other point, and that's when the disclosures take place, we raised the issue of disclosures of expenditures that were on election day, which currently is not the practice here. And we did that because so much money is spent on election day for busing people to the polling place, for robocalls, for direct phone calls to potential supporters to turn out. There is a lot of money that's spent on election day. And the reason why you would want it disclosed is not that it's going to change the election because the election is over, but for enforcement, so that you know whether or not there was a violation. Otherwise, you don't get that information until the following January 31st. And the person has been sworn into office and been voting on things in the meantime, when maybe they should not have been. Thank you.
Mr. Chair, could
Yes.
I ask Mr. Bush a couple of questions? Or would that be out of order? If it is, that's fine.
It's not out of order. I would ask that maybe we do public comment, and then we can bring Mr. Bush back up for some questions.
Hello, I'm Rob Van Ravensway. I was on last year's civil grand jury, and my comments, a general comment about this whole amendment. We'd recommended that there be some sort of a statement about how the amendments further the purposes of the ordinance in any amendment, because your power to amend the ordinance is predicated on that the amendments further the purpose of the ordinances. It can be a pro forma statement. It could be more than that, but there's not even a pro forma statement. And if you look at state amendments to the Political Reform Act, which can also only be amended if the amendments further the purposes of the act, there's at least a pro forma statement placed in the enacting clause saying that this amendment will further the purposes of the act. And there's been some discussion about how some of these amendments might further the purposes. On this particular section of amendments, it's unclear to me how this is going to affect the data sets that are currently being posted on the Commission website, whether it's going to expand it or contract it when there's talk of relying on state filings instead. And I think it's worthwhile to get some sense of whether it's going to increase disclosure or not. Thank you.
Will it?
Oh, should we go for public comment?
Do you know, is it an easy, quick answer?
The only thing I would say is with respect to how it furthers the purposes of CFRO, we do have it in Section 1 of the amendments, it's enhanced the integrity of the election process. And with respect to the memo, we try to, at the end of each section, specifically state why it furthers the purpose of CFRO with a reference to those, to the applicable provisions. So, in other words, it's both in the proposed language as well as in the memo itself.
Sorry, I was referring to, is it going to affect what's on the website?
Well, it certainly will affect what's on the website because the forms will be different. So, ultimately, the goal is to get to electronic filing. Now, the 496 will always, the state forms will still be there. They are there now electronically, so they will be there. The goal would be to get the other two forms there. To me, it'll be easier to read, certainly, because you will have one form that's electioneering and one form that's member communication, which we can upload immediately. That ultimately, hopefully, it'll be electronic. Right now, we have this 11-page form where people fill it out, and it's impossible. It's very difficult to figure out what's being reported just from watching. So,
sorry to interrupt public comment.
Yeah.
No worries. Good evening. My name is Jonathan Mincer. I'm an associate at the Sutton Law Firm, and we submitted a letter to you guys, I believe, on Friday that is in the agenda packet. I just want to speak broadly to the amendments that are being proposed today and really urge the Commission to adopt them without delay. So the Sutton Law Firm specializes in political elections law. We have many candidates, both candidates and committees in San Francisco, who are affected every day by these laws. And to put it simply, these laws, as Mr. Minardi has addressed before, are very complex and just regulation on top of regulation. The amendments that are being proposed are simply a simplification to make a standard threshold for reporting, a standard timeline, whatever it may be. There's no reason why, under the current system, that we need multiple forms being submitted to both the state and local entities for the same expenditure. So the same goes for disclaimers, which you guys haven't gotten to yet. But again, the complexity of having multiple laws on top of each other is really not meeting the actual purpose of the Act, which would be to increase compliance and disclosure. I believe that the amendments are taking a big step in order to fix that, and I commend staff for recognizing truly the inefficiencies in the system, and in order to try to make them a more simple and a more simple system as opposed to complex. As we wrote in the letter, we believe that the amendments are being proposed are, again, more simple. They're not benefiting one political side or another. It's just an aim in order to create a standard system so that all political actors within the city know what to do moving forward. To the degree that you may believe that you need to hold over these suggestions, I thoroughly encourage you to take action as soon as possible. As has been mentioned before, with the November election coming up, which will be a very large citywide election, the 90-day reporting period, if my math is correct, should already begin mid-August. To get these everything finalized and on the books, we do encourage you to please act as soon as possible. And again, the real purpose, the main aim of this is really to create a simplified system in order to help people comply with the law. And having these on the books as soon as possible will really help with that. And for those reasons, we really encourage you to act on these simple reforms and do it as soon as possible. Thank you so much.
Sorry, what was your name again?
My name is Jonathan Minster. I'm an associate attorney with the Sutton Law Firm.
Thank you.
Mm-hmm.
Good evening. Ellie Abdoli with Nielsen Merksimer. I, too, am a practitioner in election law at Nielsen Merksimer. I've represented a number of campaigns in San Francisco, and I'm a very active San Francisco voter and resident. So I care about this law both because I'm advising clients, but also because I'm the one who reads the fine print on the back of the flyers and checks out reports when I'm curious who's funded something. So I'd like to start with saying, we absolutely support the changes recommended and are very excited about the direction that the Commission and the staff are taking in terms of cleaning up these laws. And these laws really are, as Mr. Minardi said, a cleanup of existing issues, inconsistencies. The prior gentleman spoke about the database. I think it's going to improve the database because you're going to see consistent filings that a reporter can actually compare. So, for example, with the third-party reports right now, they're interpreted so many ways. You have one person reporting the total value, let's say, of a mailer and suddenly making it sound like they spent $100,000 on a candidate, when the reality is that portion was just their candidate's name written as an endorsement. Whereas the next person who might be able to afford attorneys at a firm and have a lot more resources may figure out, okay, you can only do it, you only have to disclose this portion. So it creates inefficiencies in the system, it creates inaccuracies because it's not consistent. What I've been hearing so far, and I've attended the public hearings, I'm not hearing objections to the content that has already been proposed. What I'm hearing is, let's do more. And I absolutely support that. But just like any project, clean what we have now. And I think the recommendations made are, let's clean up where we're starting from and then explore all the great suggestions that we're hearing from the public. But I encourage you to not delay this one because these are cleanup changes. We get to start from clean scratch, look at completely different proposals. If we think it's daunting now, if it's a big packet now, I suggest that after we've gone through a few public hearings and heard even more about what people are recommending, it's going to be an even thicker packet at the next meeting. So I recommend that we definitely approve this. So thank you so much.
Sorry, and ma'am, what was your name again?
Ellie Abdoli,
How do you spell
Elli, and the last name is Abdoli.
Thank you.
Thank you.
Good evening, Commissioners. My name is Kevin Hennigan. I also am an attorney who practices political and election law. And I haven't had an opportunity to review staff's proposed changes line by line. But as everybody has said, I think the impetus behind it is a good one, to streamline and simplify. There are times during an election cycle when I'm reviewing a mail piece that might feature, a list of endorsers, where I have to talk to my staff about 8 or 9 reports that need to be filed for one piece of mail, which might only cost $4,000. The amount of paper that gets sent from our office to the Ethics Commission, there's so much disclosure that it actually makes disclosure, I think, not as effective. And as to the timing, I think the timing is important. It seems like the commission is one step in this process. After it leaves the commission, it still has to go to the Board of Supervisors, be heard at a committee multiple times. Then there's the 30-day rule that prevents the board from hearing it. It's got to get passed, public hearings at the board. You're going to get very close to that 90-day reporting window in August. So I urge you to move forward with what you can and hold over what you want as well. But I'd like to commend the staff on a great job. Thank you.
Mr. Keene, did you have some questions for
If I may,
Mr. Bush?
yes.
Mr. Bush?
Mr. Bush? Mr.
Do I need my notes?
Yes.
You always do, and Commissioner Keene's asking you questions.
You don't have the right to remain silent. Mr. Bush, one of the things that's still somewhat part of my concerns in regard to us doing this is that the suggestion that there have been a number of things that the Commission itself has passed or recommended that bears on this particular matter that we're talking about, and the third one. Over the course of the last couple of years, we've passed various things and recommended various things, and those have not been incorporated in these proposed changes, and that the staff has not addressed the fact that perhaps they should be incorporated within these proposed changes. I don't know whether Mr. Minardi is aware of that. I think that may have come up. You've got it in some respects referred to in regard to the public comment, but could you outline for us what concerns you have about things that you know that we have done? Because our institutional memories are pretty bad, I have to say that.
Well, one of the things that the Commission acted on in May of 2013 was an amendment to increase the prohibition on contributions from contractors from the current 6 months to 12 months. And that has not been incorporated in this provision. Also, the Commission passed a request for an amendment to be drafted by the staff for reporting and disclosures by draft committees. Those are committees designed to draft someone who's not yet a candidate, which arose out of the Run, Ed, Run campaign when the Commission determined that it did not have jurisdiction to require disclosures at that time. So they passed then in November a request to staff to draft an amendment to CIFRO to cover draft committees. That's now, 3 years and counting? Or 2 years and counting. I'm not good at math. I'm good at language, but not math. So that's the second one. There was also a decision this past August for the Commission to take up consideration of banning lobbyists from making contributions. There's nothing on the agenda that's taken place in the 5 months since then, and there's nothing in here that suggests that it's going to come up in the future. The issue of reducing reporting thresholds from 5,000 to 1,000 for independent expenditures by committees or persons on behalf of a candidate or measure is not included in here. The Commission discussed making it mandatory that the contribution forms specifically state that contractors are not permitted to make contributions. So those are some of the examples of things that were passed by the Commission but which are not included in here. The larger issue beyond those specific things is that where the Commission has run into a public buzzsaw is narrowly parsing how something can be viewed, like on draft committees as an example, or that they cannot act in the case of a commissioner only on staff or department heads. And after those narrow views were determined by the Commission, there was then no subsequent action by the Commission to try and close those loopholes. And so all the loopholes that we saw before continue to exist year after year after year, even though the situation continues. You can take as an example the Airport Commission president, Mr. Mazzola, who on its face appears
Mr. Bush, I mean, there's a lot of stuff that we could throw out, but I'm trying to focus for Mr. Minori in regard to those things that we have spoken to and said this should be done.
Yes.
And they bear on this, and I'd like us to discuss why we're not recommending that they be in there, rather than just a potpourri of all sorts of wish lists that we like in a perfect world. Those are great, but that's not. I think my colleagues will get very angry at me if I open it up that much, and they should. So just in regard to those things that we've said, this should be done, and that are not in here.
Right.
And then I'd like Mr. Minority.
I think I've given Mr. Minority a list of those.
That's right. Commissioner Keene and Commissioners, this is on, I don't know if you can reference Mr. Bush's letter on page 2. There's a list of 6 items, specifically which he just spoke on. I think he mentioned all of them.
Yes.
And let me just say
Can I ask in regard to these 6 items, have you reflected and analyzed them and made a conscious decisions as to all of them as to why they should not be encompassed within these proposed changes?
Not with respect to all of them.
Part of the reason why I wanted to take a little time here.
Yeah, that's right. Okay. That's good. No, this is good. Well, so let me. If you don't mind, I mean, I can go through these 6 with you and sort of tell you about them and sort of where they were. And
why don't you, Mr. Chair? Why don't I suggest we not do that? And since we've talked about the fact that it's going to be bifurcated, that these now that staff provide us with a memo in regard to those, so that we can think about it for the next time, and then really come back with some exhaustive thought as to whether we want to incorporate them or not incorporate them.
Well, I do have some concerns about holding up regulations if we all agree that we should make changes for things that we also could and maybe should address. And I don't think they're mutually exclusive. I don't think we have to hold up the whole to do what we, if we agree there are other things that need to be done, and we can put it on for next month as well. Okay. We can put these new ones on for next month as well. But I don't think we have to do them all together.
That's fine. Then we can go ahead, deal with what we've got, vote on it, knowing that we're going to revisit this next time for perhaps some augmentation.
Sure.
Okay, just one short comment, which is the first one with respect to the draft committees. My understanding is that a few years ago that this actually was passed by the Commission and was shopped to members of the Board of Supervisors, and it basically didn't go anywhere. Yeah. So in terms of going forward, I'm happy to discuss all these issues, definitely, but I'm not sure about that one. If you want to revisit it, we can. We certainly can.
Well, perhaps since we're talking about the fact that we're going to have some augmentation of what we're going to vote on, we're going to vote on these things today.
Okay.
But we're going to have some augmentation. Perhaps you can just provide us with some analysis as to those matters, as to why perhaps we might want to recommend that those also should go into this or not.
Okay.
All right?
What, may I ask one question just about that? Sure.
You know what? Let's.
All
I
right.
mean, we can.
Yeah.
That's an agenda item for next month. I think.
Sure.
I think the commissioner has made clear what he wants, and we can talk more in detail about the agenda when we get there.
Okay. Gotcha.
You know, one thing that Ms. Abdoli raised that that does concern me is, I mean, are we talking about some significant objections to what is been proposed, or is this mostly about other things that we should be doing that are not included? Because you know, I am having a hard time figuring out where the real disputes are between people who are unhappy with the proposals and what we're proposing.
Well, without certainly trying to put words in people's mouths, my understanding is that as a general matter, most folks are on board with the concept of streamlining these reporting requirements.
Of course, but obviously the specifics matter.
And then some of these along the edges, again, with respect to the member communications issue.
So what number are we? Is that 1.162?
That's 1.163 is the member communications. The new 1.163. So let me get the page.
Right, that's on page 10 of the memo.
Right.
But isn't there also some concern with 1.162?
Definitely. My understanding is the concern is that there will not be vendor reporting for electioneering communications under our proposal, and that there should be vendor reporting, even though that would be different than, say, what's required under state law for independent expenditures.
I'm sorry, because vendor reporting is currently required and we would be removing that?
We would be removing it, so that would be all the requirements for reporting would be consistent with what's on the 496. That's correct. Okay. Yeah. I'm sorry, which is the state form for independent expenditures.
Okay, so those two, 1.162 and 1.163, there's
and then Mr. Bush. And then Mr. Bush, I think, said that there should be an expansion of the state law requirement so that there is reporting, 24-hour reporting due the day after the election.
Do we currently require that?
No.
So this would be adding, this is not a criticism that we're removing something that's already being required.
That's correct.
Okay. How do the commissioners want to proceed? Like I said, I'm hearing Mr. Bush and saying that there are other things that we need to address. It does seem like a lot of these things there's not really much dispute on, and I do have some concern that we're not going to be able to send it to the board in time for it to be relevant to this election. At the same time, I know it's a complicated matter and there's a lot to digest. So I'm happy to defer this to the next meeting. But if we feel we have consensus on this, I'm also happy to go forward.
I'm satisfied with the discussion, and I thank the indulgence of my colleagues that in regard to the substance of what's there, we could go forward and vote on it with the understanding that we'll have this back on the agenda next time for possible augmentation. I think that might be a good way to do it.
Mm-hmm.
So it's satisfying
Commissioner
me
Hand?
anyway.
When do we need to get it to the board?
Well, I'm not sure there's a clear answer to whether if we get it to the board on X date, it'll definitely be in place for the election, but why don't I defer to the city attorney or staff on recommended timing?
Yeah, so it may be helpful to just think a little bit about the timing issue right now. So I think whenever the commission approves the final version of what it's comfortable with respect to this round of CFRO amendments, you have to add a minimum of 2 months for the Board of Supervisors process. And that's assuming the Board of Supervisors has no further amendments to what the Ethics Commission is proposing. Now, if any member of the Board of Supervisors wants to make a further amendment that will require a re-referral back to ethics, it can easily tack on another month or two. There's a few procedural things at the board that make it a significant timeline. Also, as well, the fact that the Ethics Commission meets only once a month. In the past, the Ethics Commission has met sort of on a special meeting basis to deal with legislative changes like that. But yeah, something on the order of 2 to 4 months is realistic. As to what would be necessary for the people out there who need to comply with all this stuff, certainly would need to be in place by early August, but I assume it would be even better to have it in place a couple months in advance of that. I would defer to Jesse on that.
First, I would think.
July 1st.
That would be the best.
Yeah, so I mean, the next meeting, end of February, would probably be, even if the final version was adopted at the next meeting, it would still be a close call. Let's say that.
Okay. That's helpful. Commissioners, any other questions?
I was wondering if I heard that correctly. Would you say it? I'd say, I don't want to put words in your mouth. You're saying even if we continue it and we pick it up at the last minute, at the next meeting, I was more thinking that would be our kind of sort of last chance to really get it in and feel good about the timeline, even the protracted timeline that we may build in.
Yeah, I think that's right.
Okay.
I mean, I think to sort of reasonably expect this would be in place in a fair timeline to all the affected parties in advance of this November's election.
Yep.
I think you would need to get something out at next month's meeting.
Got it.
I mean, is it a thing where our chances are appreciably better if we get it out now than if we get it out next meeting, or do you think that's kind of 6/2 dozen?
It's hard to say because, frankly, it's going to depend on one of the big factors here is sort of the energy and focus of whoever becomes the legislative sponsor of this proposal at the board. I'm not sure if that person has been identified yet, but a lot of it is going to depend on whichever supervisor takes this up and how quickly they try to get through the process.
Okay. Any other questions?
And are there other competing activities? I don't know if the board is working more or less to get there. During the budget season, obviously, they're pulling their own proposals together, and I don't know that. I think they're working on them now, frankly. And it seems to me that I don't know, but it seems like next month may even be a later time, a better time, because I think they're getting their proposals in sooner rather than later.
Right, and certainly the budget process is always a significant chunk of the board process. Starting through the spring, through the summer, really. So.
Okay, so how shall we proceed? Is there a motion on this?
Yes, I move that. I think we have one more aspect for discussion, don't we? And then I think I'd have a motion in regard to all of that, just sort of prospectively. That is that in terms of voting on those three things, that we vote on them, send it to the board. So they then have that. And then, if necessary, we augment it with something next time. So they are in the process in terms of the bulk of what our efforts are supposed to be tonight.
Agreed. So for decision point 1, we voted to adopt it. Is there a same motion for decision point 2, or would the commission rather deal with 2 and 3 together?
Perhaps we should. I'd move 2, and then we could have the presentation on 3. And
okay. Is there a motion to adopt decision point 2?
So moved.
Second?
Second.
All in favor?
Aye.
Aye. Opposed? Hearing none, that motion passes. Let's go to decision point 3. Mr. Minardi, you can hear from the public.
Commissioners, this item, or this part of the amendment concerns the disclaimers, that is the statements that have to be included on communications that are sent by third parties, actually, and also candidates in this case, when they're sending out campaign communications. And again, we get to this issue of sort of complexity and overlap with state law. And the entire sort of gist of this is really just to make city law essentially defer to state law, but then augment it in 3 key ways. And we put this basically on page 12 of the memo that says, if you are sending out mailers or you are posting up, ads on a website or whatever, radio ads, et cetera, the general guidance is look to what state law says and comply with that, which is what they already have to do, but then do 3 things which will, we think, sort of augment disclosure, and that is with respect to mass mailers and smaller printed communications. They should use 12-point font. Right now it's 10-point font under state law. And there's, at the end, there's sort of an example of kind of what city law is, what state law is, and what we're proposing. Comply with a lower $20,000 threshold for disclosing top donors. It's a $50,000 threshold at the state level. Our understanding of this new requirement is that it would allow for more disclosure earlier on in the process. Once they got to $50,000, it's basically the same as the state disclosure rules. And then finally, in an attempt to leverage sort of the really good, well, in our opinion, really good stuff we have on our website, include a reference to the Ethics Commission website telling somebody who wants to know, hey, if you want to find out more about this, go to the Ethics Commission website. And it also, one final thing is with respect to, this applies with respect to ballot measures as well as candidate committees. So it's a little bit different than what we're talking about before. It's a little broader. And also there's a rule that candidates who under state law are generally not subject to a whole lot of disclaimer requirements would have to basically comply with the requirements for independent expenditures. So again, the intent is to simplify, streamline, and yet provide for full disclosure.
I had a couple questions. Well, why don't we take public comment on it, and then we can address questions. Public comment on decision point 3.
I want to talk about anonymous donations, funding campaign communications, and how that should be disclosed. I don't think the staff analysis of the grand jury proposal really does justice to it. They cite 2 national writers who basically support this concept, and elsewhere in their discussion, they talk about Cass Sunstein at some length, and this is the sort of regulation that he really does support because it nudges behavior towards disclosure. On a national level, anonymous funding of campaign communications really took off in the last cycle. I mean, it's gone from a relatively small part of the pie to a really huge part of the pie. And I think staff should also be analyzing what went on in the last election cycle in terms of the state assembly races here in San Francisco, where a lot more money came in. And in general, I don't think there's any question that the level of funding for races in San Francisco has increased dramatically in the last 10 years. And when funders know they can attempt to do things anonymously, particularly people coming in from out of state, even if it's going to be disclosed eventually, you get through the election cycle, and then you kind of worry about that later. So the idea is really, if you're going to put a disclaimer in the ad and you're funded anonymously, say you're funded anonymously, and people can kind of evaluate that message. I mean, this is not trying to say, oh, this is only funded by big donors, or this is only funded by out-of-state money or out-of-district money. It's really the question of whether people are willing to stand behind what they've put up money to put out to the public. And I'll tell you, I mean, ads are coming in from all kinds of sources these days. I don't watch TV much, and San Francisco is not a really good TV market for ads. But on the web, on your phone, you get all kinds of smash-mouth ads in the last election cycle. And there really ought to be some disclosures in there about where the money's coming from. And I think that's important. And I think it's also important that the Ethics Commission looks to get out in front on some of these issues and not try to just fix it after the fact, because then the election's sort of come and gone. So, thank you.
Thank you.
Good evening again, Jonathan Mincer. I just want to make a small specific point on the issue of disclaimers. I just want to emphasize that these proposed rules are really strengthening the current system, a San Francisco system, and I don't think it can be argued that they are in any way weakening or that there's any controversial point that it's taking a step backwards as it is. In our letter, we cite just one example to give you kind of an idea of the effect of overlapping regulation, whereas one advertisement done by IEs might require a 14-point disclaimer, a ballot measure ad might require a 10-point disclaimer. We also discussed how billboards in San Francisco, and I believe this was a point also raised in the memo, only require a 14-point disclaimer as opposed to 5% of the height, which is a state requirement. So again, there's just little examples like this, and I can keep rattling them off, of areas where the San Francisco law may have an issue that is not being fully addressed, and I think the state law does that well. And again, to the point earlier of making compliance easier with the simple rule of state law plus 3 additional items, I really think it helps, many actors and many political actors, especially those who are less sophisticated in the community, in order to comply with the laws and not get dinged on little fines for not having 10 points or 11 points or whatever it may be. So that is one point I want to emphasize. And to the comment about anonymous contributions or anonymous donations, I would like to, just kind of mention that in the past year, SB 27, which was passed by the state legislature, amended or added a new article to the election code, section 84222, which requires multi-purpose organizations to disclose all the donors, all donations that were used to fund political advertisements. So thank you so much.
Comments, questions from the commissioners on this?
Just that in regard to our augmentation next month, Mr. Chair, if Mr. Minardi could analyze for us the whole aspect relating to anonymous donors as well. That was raised by the foreman of the grand jury. I think that's an important point. So we could visit that next time.
I agree with that, and I wonder if there's a quick fix to that. So right now, I'm looking at Appendix E, and what we're proposing, I understand, is Example C.
That's correct, yeah.
Why would it achieve the same goal if the major donors who are anonymous are we just say that?
Well, I guess I would just say that we took about a page and a half to address this issue out of the memo in terms of why we didn't include that, and I'm happy to go through it if you want to talk about it now, or we can. But essentially, it's sort of it's a twofold thing. One is a question of justification for the need for it, which, quite frankly, I don't see at the local level. I mean, I state it plainly here, primarily for two reasons. One is that, as Jonathan mentioned, the state law disclosure requirements are quite different from the federal law disclosure requirements. Those are incorporated into our law. And if there is an agreement to use funds given to a nonprofit, and there's an agreement to use those funds for ballot measure or candidate activities, those are disclosable funds. Then it becomes an issue of enforcement. But those are disclosable funds. Even if there isn't an agreement, if a nonprofit spends $50,000 in a year on anything, contributions, expenditures, they have to start disclosing their donors. So this just passed this past year, and it's quite robust. So that's number one. Number two is that we have an electioneering communication rule, which says that if you collect money and you send out not IE ads, but electioneering stuff, so you don't use the magic words, 500 or more within a 90-day period, you have to disclose the donors that you use their funds. So this is a different, the regulatory regime is different at the local level. The need, quite frankly, a lot of these nonprofit groups, they have PACs. They use the PACs, they disclose their donors. And then as a general matter, what we say in the memo is this is different than, and you know, there is Professor Gherkin who said that came up with this idea, obviously much smarter than me, but there are certainly very smart people who disagree with this, including a number of local or national figures who say, hey, look, this is different than saying top donors, because top donors serve as a key for people to say, that's the person. Oh, well, you know what? Maybe I like them, maybe I dislike them, but it's a shortcut. Saying somebody is not disclosing their donors, the criticism is, which I agree with, that's a fact, but there's a direct implication in a way that donor disclosure doesn't have, which is you're not disclosing your donors, and you should be. And you're trying to get around letting us know who it is. And that's a negative statement, which, quite frankly, it's not clear that the government should be sort of having somebody say by implication. So to me, it's a couple of things. One, it's a need for it right in terms of the law, a need for it in terms of the fact, and whether it's actually wise policy. So that's what we put in our...
Let me ask you a practical question. So I'm looking again at example C from Appendix E. If my top two major funding donors are anonymous, what do I put there right now under the proposal?
This wouldn't apply if they were anonymous.
So then you would just that line would be blank. This would be a 1, 2, 3, 4 line disclosure, not a 5-line disclosure.
There wouldn't be any disclosure. There would be. Yeah, there wouldn't be any. Yeah.
Yeah. So again, this is, I think, the first point that Jesse made. That look, this policy or this proposal from Professor Gherkin and others, it is much more applicable to federal elections, not local elections in California. In local elections, California, a major donor for the purpose of this threshold, the $20,000 threshold, will not remain anonymous.
Yeah, they're not going to remain anonymous. That's right.
So you're saying that you could not. Every disclosure is going to disclose their top two major donors by law, basically.
Yeah.
If they're an IE, if they're an independent expenditure, they will.
Okay.
But where's the harm, though, in adding the term anonymous? I mean, you've given a good, all-encompassing argument saying, well, we've got it covered. It's taken care of. Why don't we put in specifically the word anonymous? I don't see how that in any way is then a problem. You haven't told us that the adding of that term is really a problem, unless I've missed something. I mean,
probably not.
I think he's saying, and
I may be missing.
So I may be too.
I'm not the brightest bulb.
I know. I'm struggling myself
when it comes to some of this stuff.
But I think what he's saying is that you could never, in this situation with an IE, have major funding by an anonymous donor,
right?
Because you have to include the names of the top donors.
Right, and so to respond to Commissioner Keene's question, and this is this is certainly technical stuff, and I think Jesse's great at this stuff, but it's certainly beyond me in many circumstances.
All the rest, though.
Yeah, so yes, I guess theoretically you could have a provision in here that dealt with anonymous donors, and those anonymous donors were sort of major funders, which obviously people would really want to know about. But the problem is, for those people to exist and to be subject to the disclaimer requirement, they would have needed to already have violated state law. So we would have a provision in here saying, look, if you already violated this state law about what you need to disclose, then we're requiring you to put this disclaimer statement on here. I guess that
What do we lose by that?
We could do that. We could. But that's the situation.
We obviously have a concern on the part of a good portion of our citizenry, the civil grand jury, in regard to it. If, as you concede, we don't lose anything, let's put it in.
I think what the civil grand jury is requesting is a little bit different. I think they're saying that any time there's an anonymous donor that paid for any portion of the hangar, for example, not necessarily one of the top two donors, then you put on this statement that it was paid for and funded by anonymous donors. So it wouldn't be the top two. Am I saying that wrong? So it wouldn't necessarily be the top two, but if anyone was anonymous, then you would add a line here that says, basically, some of the donors for this were anonymous. Do I have that?
No, our concern was really the 501c6s and so forth that basically go, we're the committee for justice or whatever, and we don't disclose our donors, period.
Okay, so then is...
So I mean, you see this committee's name, and maybe they're donating to another committee, but, what's behind that, you just don't know. Maybe you find out later. So,
okay, but you heard Mr. Shen say the situation in which the top two donors are anonymous for an IE could never happen because that would be an admission of a violation of state law.
We'll see. I mean, people have been getting very, very creative, and when you start chaining a lot of entities together, and the money's flowing from one to another, it can take a year or two or three to unravel all of it. But the ads are running in real time.
But what I'm hearing is that
and they really, at the federal level in the last cycle, they really contributed to just an awful environment, for people turning on their TV set and listening to this kind of trash all the time. And, I mean, at some level you want to say, let's get the discourse under control a little bit and, get back to some kind of civilized discourse. And when it's anonymous funding, there's really no checks on it.
Thank you. Okay.
Are we still? We're back on the anonymous. It just feels. I'm thinking at it from a different angle, which is, it feels like we're encouraging anonymous donors, like we're creating a provision for them in some kind of way. I just don't understand why we would.
Why we would place that. Can you explain this perhaps better than others?
I don't think I can
really
explain it better than
understand the law.
Mr. Marinardi and Mr. Shen, but to try to cut to the quick, there's no way in San Francisco or in California that anonymous people will be funding independent expenditures.
That's right.
All those forms we talked about in decision point 2, within 24 hours of a mailer being mailed, you're going to be able to go on the Ethics Commission website and see every contribution of $100 or more that was used to fund that mailer within 24 hours. Okay? So to Commissioner Keene's point of what's the downside, the downside is it's not true. It's inaccurate. It would make the mailer seem as if some anonymous people are funding it when the Ethics Commission will have records in their possession which disclose every donor who's contributed to it.
Well, anonymous people could be funding it if they didn't meet the threshold.
The threshold for anonymous donations, I think it's $25 or $99?
Well, certainly if there's an agreement saying, hey, we're going to fund,
Yeah.
here, that it's $1. I mean, if there's an agreement,
That was $99.
Under California state law, you have to disclose those donors. Meaning, if you say, I'm going to write you a check and use it for you're a trade association and I want you to send out a mail piece. As soon as I write that check and there's that agreement, that's disclosable at that moment. What's not disclosable is the threshold, the $50,000 threshold in a year is if there's a nonprofit that's sitting there that decides they're going to do an IE and they've basically have a store of money and they're not taking it from anyone, but they've accumulated funds over the course of the year, and they decide we're going to weigh in, so we're going to send a mailer out. So they can send a mailer out and they'll have to disclose that they sent it out and that they spent money on it, and then there's a $50,000 threshold at that point. After they meet $50,000, they have to go through some accounting to kind of figure out how they're going to attribute it to all these various funders they've had over the course of the last 4 years. But, so that's I'm saying that right? I think I'm saying right.
Yeah. But it's, the example which Jonathan referred to, the state law was just changed. It was a very unique example, which in the 14 years I've been practicing political law was the first time that someone really tried to run money through 3 different nonprofits and dump a large sum of money into a campaign. And you saw what happened. I mean, it basically cratered the opposition campaign. It was exposed within a matter of 2 weeks, and the law got changed to make sure it never happens again. So I hope that was helpful.
What was that incident?
It was with the Governor Brown's Prop 30 campaign, and I don't know the nonprofits. There was basically some nonprofit in Virginia that funded a nonprofit in Arizona, which funded a political committee, then that political committee gave the money to an anti-Prop 30 committee. It basically went through 4 states and 4 different nonprofits without disclosing the true source of where the money came from. And it was litigated. It was dealt with at the Supreme Court of California before the election. Within 2 weeks of the story breaking, the Supreme Court of California was dealing with it.
Thank
so
you.
It's a very serious issue, but I think our rules cover it. Thank you.
Okay. 2 other questions unrelated to anonymous donors. So we're also omitting the total cost of the mailing?
That's right. For a mailer, that's correct. Yeah.
And why is that? Just because it's too much to put on a mailer?
Well, because first of all, it's a distinct rule just for mailers. So what we're trying to do is streamline it and make it one set of rules for all communications. Secondly, it's a question as to particularly if we're referencing the Ethics Commission website, where we're going to have a lot of not only just the campaign information but just the graphics. We staff, and in my experience, have not found a lot of value in knowing how much the cost of that single mailer is. The value is knowing how much, as a general matter, a particular entity is spending, as opposed to, on the one mailer that you get that's in a pile like that. So in the interest of making a sort of a standardized disclaimer, we said, we'll just take out that as well as the whole notice to voters requirement.
Am I correct that what you're doing, though, in terms of the type font, you're making the state requirement to be consistent, or the San Francisco requirement to be consistent with the state?
We're actually, for mailers and for like small, like flyers, that sort of thing, we're actually augmenting it a little bit, because on the at the state level, it's 10-point font, which is pretty, it is what it is. It's, not that big. Right now for mailers, ours is 14-point font, and you can see in the exhibit, it ends up taking up pretty substantial part of a mailer, which sometimes are quite small.
What is the state requirement for a mailer?
10-point font.
And I guess the question I have is, we get all these things that come in on 14 point or what, they aren't doing this and that. Why is that so significant? I mean, why don't we standardize it so that if people know the state requirement, they know the city requirement, and we not have all of these coming in, and I guess I should say not less than, because clearly if they came in at 16 point, you wouldn't charge them with any violation. So it's not a mandatory font size, that's a minimum font size. And it just seems to me that we ought to have just one and let it go at that.
Certainly at the discretion of the commission, but
I still have Mr. Bush's voice in my head when we dealt with this 14-point font issue, and there seemed to be a lot of concerns that 10 was too small, and we went to 14 just to make sure that people could see it. I'm not against going to 12. I think it's readable. And I understand the concern that we have a lot of information on these mailers. But I'm a little concerned about going down to 10.
Yep.
Any other comments or questions on decision point 3?
I feel like I'm torturing everybody here.
No, this is very good. You've done a fine job here.
Is there a motion to adopt decision point 3, or do we feel that we need to defer this one?
I'll move it.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Hearing none, that motion passes 5-0. Thanks again to the staff and to the public. I thought your input was very helpful. As you could tell, we could use some of the help.
Sure.
Oh, excuse me. Decision point 4.
Decision point 4 is really just to make sure that we're covered the whole thing. I've tried to be as comprehensive as possible, but there are little things like we moved one definition to a different section, and this is just to say, okay, all these minor little technical things were approved as well. You look at it.
Public comment.
I'm going to take this as an opportunity to comment on decision point 2, because this covers all of the points. I did not discuss the vendor payment issue. And I'm sorry that the vendor payment disclosure is going to be removed, because knowing who the vendors are tells you about the relationship between a candidate or a committee and various community groups. So let's say somebody wanted to pay Friends of Ethics $100,000 to do a mailer for them. That would no longer be disclosed, not under this provision that says that vendor disclosures will not be paid, not be disclosed. So we strongly believe that vendors should not be removed from the law.
Perhaps we could add that to our augmented discussion for next time.
It's okay with me. To me, it's fine to adopt decision point 4. I just ask that you be clear with us about what else, if anything, that wasn't identified. Now, I understand it's a process that you later discover it, but just let us know what it is so that we're apprised. Because what you're saying is if there are things that you miss that are minor, moot. All right. Now I'm unclear what you mean by decision point 4.
It's just that there are very minor sort of, I might not have said, for example, that we define distributed and distribution to mean the day that communication is viewed, read, or heard, which is mentioned in it's in the attachment, but it's not in the actual memo itself. So it's things that are very sort of small, but
this is what we've done before.
Yeah. Just to be clear, this just summarizes any of the minor technical changes that are already in the version presented to you.
Right. Okay.
And this is a classic Mabel Eng technique.
Yes.
And so we decided to employ it here.
Is there a motion to adopt decision point 4?
So moved.
Second.
All in favor?
Aye.
Aye.
Opposed? Hearing none, that passes 5-0. Commissioners, you need a break? Okay. We're going to adjourn for 5 minutes.
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television.
Budget directions from the mayor's budget office that we cut anything this coming year over the current year, and there's a 1% contingency for the out year. In looking at what we're planning for staff in the long term, we've determined that we want to enhance some of the responsibilities of the campaign finance staff. Given that a lot of our new electronic filing stuff, we have more data and it's becoming more sophisticated, we anticipate it will continue to do so. So we want to, through changing some responsibilities, moving the lobbyist ordinance and the campaign consultant ordinance responsibilities from the enforcement staff to the campaign finance staff, we're going to increase the level of, as I said, responsibility, and with existing staff, we'll see about getting some training and education to help them move up. And when we hire new staff, we're going to alter the requirements to those positions so that they're more sophisticated to meet some of the needs that we expect in the future as we try to do more. Additionally, the request would fund the vacant investigator position, and we're hoping to get 2 new auditors. We do a certain amount of random audits every year in addition to all public finance candidates. And audits are one of our best tools in terms of fighting corruption and getting transparency. So in an ideal world, we would audit every campaign, but I don't think we'll ever get there. But doing more would certainly enhance our responsibilities. I mean, our capabilities. Were we to get funding for all 3 of those positions, we would also effectively use up all of our workspace. There won't be places for anyone else. So if we achieve that goal in the future, if we want to, again, grow the staff, we're probably going to have to work with the city to find a new residence for the commission. We went through that once before. It's a project that runs like 3 years, but it's certainly something that might be out there in our future. And then finally, we're looking to get the money to pay for the migration of Form 700s that are filed with departments. Basically, elected officials, department heads, members of boards and commissions all file with us. And starting this past year, it was all electronic. And then once they file, those forms are immediately available to the public. There's about 3,000, maybe a little more, other city employees that also file these, but they file them on paper with their departments. So what we ultimately want to do over the next 2 to 3 years is transition those people to all filing electronically with us as well. It's going to be a big undertaking, and because all that data will be stored with NetFile, there's an additional charge for those people and that information. At some point, the FPPC is going to standardize the electronic filing format for Form 700s. They haven't done so yet, although they plan to do so in the near future. Once they do that, NetFile will then use that format to develop a more searchable format for Form 700s. So eventually, right now you can pull them up by looking for specific people. There will be other information in there that can be searched and manipulated, but that's not going to happen right away. So that's basically what our proposal is. Staffing is always, our primary concern. And so that's the recommendation I make for the commission to submit.
Questions or comments from the commissioners? Commissioner Keene?
Yes, I'm happy that you're pushing for the filling of the vacancy position for the investigator. It's been vacant too long. There's so much put as much of an effort as you can into getting that. Several months ago, we passed a resolution for all of the materials, the public materials, to be put into the various different languages that all of the other departments has put information in, Spanish, Canton, and Chinese, and stuff like that. Has that been done?
It's not completed yet. We're working with the city to basically meet the requirements. They're going to sort of hold our hands and walk us through the process. I believe it'll be done before the end of the year.
Okay. Is there any expenditures that you expect that might be?
We don't know. We don't know because they are trying to make it easier for us. I did anticipate that there would be, but without knowing what it is, probably at the point we know, we'll ask for an additional amount of money from the board and the mayor, separate from the budget process.
Would you know that before you put in your submission? If you do need these additional amounts, because what I'm suggesting is perhaps you might want to make some sort of estimate and put that in there so that this isn't held up.
I'll try to get some kind of number out of them, but I don't know what it is. And based on our conversations, I do think there's going to be an expense. I hope it's not as much as I had originally feared, but I don't know that yet. But
you originally told us that you thought you would have it in the department. You would have it in your regular budget when we passed this. That was the last thing that you said after we passed it.
But I don't know that the estimate that I had for it then is going to be anywhere near accurate.
Which was zero then. So it's you said we'd have it in the department. Do you think that's changed, or?
I think that I had calculated a figure that I thought it would cost at the time, but again, I was
right. I'm wrong about zero, but
yeah.
You said you sort of reassured us that you had the money, but now it seems that you may not. Is it?
If I can make it work, I will. If not, we're going to have to get a supplemental appropriation. I don't think that'll delay it, and I'm hopeful, maybe even positive, that if the city realizes what we needed that for, that they would see to helping us do it.
I think they would, yeah. All right. So I'd encourage you to really make that a priority.
We're going to make it happen.
Thank you. Thank you, Mr. Chair.
Yeah, Mr. St. Croix, so I'm assuming from Commissioner Keene's comment, some funds obviously could be fungible. So if I recall, I think you had already, there was a past budget that may have had a vacant position salary dedicated that ultimately wasn't being filled, but there were funds that were available, not enough to hire that person, but maybe possibly some funds that were there. And you want to spend your funds, I mean, and I think there are appropriate ways in which you can do that. So there will always be that case, frankly.
Yeah, and they are fungible. I mean, it's not automatic. We can't just do it.
Yeah.
And we have to get
right, you have to get approval.
Permission from the mayor's budget office, and usually from, like, if it's personnel, from DHR. And there's a process in place. It hasn't worked for us 100% of the time, but most of the time it has.
Most of the time, yeah, I know. It can. Two quick things I wanted to find out. Are there any occupancy requirements for you? Do you, as the commission is and ethics, do you have to be in a city-owned building?
I don't think the city would give us the rent to move to a private property when there's city space available.
City space available. Mm-hmm. Yep, got it. And then I was just thinking, probably for our own edification, just to see it's a bit of a strategic plan that would come to us in the form of an organizational chart. I think it would be great to see what it would look like, the org chart, your proposed org chart, as it relates to the increase, the request of a little over $300,000, just to see where you're headed in terms of staffing, and then where you're putting your resources.
Okay.
We'll propose something.
And I just want to point out, even though we're in a city property, we still pay rent.
Oh, yeah. I figured. I just didn't know if you could pay rent anywhere.
We didn't ask for public comment yet on the budget, but
Yes.
we did get this email from Mr. Bush in which he raises some questions, and I just wonder, Jack, did you look at that and give any consideration to, for example, going through the grand jury report and where we might have agreed with their recommendation but said there were no funds, that whether or not we ought to include a request for it, and it may get rejected, but at least it shows that we're making an attempt.
I haven't seen that email.
You haven't seen the email?
No.
I had one question about the net file contract. We shopped that at all? Do we know that we're still getting a good deal from NetFile based on what else is out there in the market?
There's really only two vendors in the state that do this, and the other one wouldn't be able to meet the demands of our capabilities right now. We're in the first year of a 3-year contract, renewed contract with them. And the language in the contract will allow a renegotiate for this particular function that we want to do. But as from my perspective right now, they're really the only people that can meet our needs. And we have to go through a very rigorous process when we let a new contract to have a sole source contract for us. It's the only contract we have, and 7 different agencies have to sign off on it before we can do it.
I guess I just want us to be cognizant that, we signed up with NetFile, we were an anchor tenant, we got a good deal, and if we feel we've sort of become beholden to them and could never move, I do worry about whether our ability to, keep this at a reasonable cost is potentially compromised. So I have some concerns about becoming too beholden to any one vendor, frankly. Public comment?
Thank you. I'm Larry Bush. I'm speaking for Friends of Ethics on several budget issues. I was delighted to hear that Mr. St. Croix thinks that the Form 700s will be searchable, because that will make a big difference in terms of being able to see where the conflicts might exist. The grand jury also had recommended creating an electronic database on contracts for the same reason. And I would like to recommend that you ask for a budget, whether you submit it now or not, at least know what it would cost. Because currently, as I understand the process, you receive the contract notifications by email, and then they are essentially put on as a PDF. So they're not searchable to go through. In the same way, it also be true on behested payments and on travel money. It's worth noting that there was an opinion from, I believe it was the Rimcho law firm, that stated that no one may make a gift to an official of more than $440. And right now, that's an aggregate for the entire year. Travel money is not excluded from that. And yet, we know that we are seeing people who are giving $500 or more for travel. How much more and for how many other trips and what other gifts they gave, we don't know. So it would allow for a better enforcement of those kinds of things. It's just a straightforward thing. So it's contracts being searchable. It's making behested payments and travel money electronic, and the FPPC, which is really the file where a lot of this goes, says that they have no problem with us doing that locally and adding additional stuff. And then also we had recommended that there be a commission secretary position created in addition to the executive director. There wasn't money for that. And the recommendation was that you could do a part-time commission secretary, at least to follow up. And I'll give you an example of the kind of follow-up that appears to be missing, judging from what happened with Mr. Grossman, and that's whenever someone files a complaint with ethics, they are supposed to receive under the charter a notification back that the complaint has been received. Then if it's then turned over to the DA or the city attorney, they are to be notified if it's been returned, and if it's been returned, is the commission going to take it up or not, and what are the reasons? And our investigation showed that those notifications are not taking place. And I think they're an important part of not only transparency, but also public confidence in the work of the commission. That could be done by a commission secretary. There's no reason to take up the executive director's time. Thank you.
The next item on the agenda is, oh, sorry. Is there a motion to approve the budget request?
So moved.
Second?
Second.
All in favor?
Aye.
Aye. Opposed? Motion passes. Next item on the agenda is discussion and possible action regarding a complaint received or initiated by the Ethics Commission, possible closed session. Public comment on item number 6. Is there a...
I'm sorry. Can you identify whether the complaint involves campaign funding or lobbying or conflict of interest? Just in general terms, what category does the complaint come under? Whistleblowing?
Mr. Minardi?
Yeah, we identify it in the agenda. So there are 2 complaints, and we do identify the code sections that are applicable with respect to those complaints.
If only I knew the code as well as you do.
Oh, sorry. Well, here. Campaign Governmental Conduct Code 3.216, receiving a prohibited gift from a restricted source. And then the second one is just failure to file a semi-annual 460, failure to maintain campaign records, and failure to pay accrued expenses in 180 days. So
Thank
those
you.
are 2 separate ones.
Is there a motion to go into closed session?
So move. Second.
All in favor? Aye. Opposed? Hearing none, that motion passes, and we will move into closed session to deal with item number 1 relating to San Francisco Government and Conduct Code 3.216.
welcome to Johnny's Free Hotel. Stay as long as you like. You all will get used to the smell of living at Johnny's Free Hotel. Yeah, it's a derelict's mind, the minds of those who inebriated, ones who never made it. Yeah, it's a derelict's mind. People point the finger, they disgrace us, but in truth, they'd rather close their eyes than to face us. 1, 2, 3. So welcome to Johnny's Free Hotel. Step right up and meet your maker. You just did all your time in hell if you've been living at Johnny's Free Hotel. Step right up and meet your maker if you've been living at Johnny's Free Hotel. Step right up and meet your maker. You got a clean slate. You ain't got nothing to worry about if you've been living at Johnny's Free Hotel. You're in love, hearts are fluttering all day long, only stuttering 'cause your poor tongue will not utter the words I love you. Ooh, what the moonlight'll do to you. Wait a while till a little moonbeam comes peeping through. Yeah, you'll get bored, can't resist her, and all you'll see when you've kissed her is ooh, what a moonlight'll do. Stevens on the drums. Next, we're going to feature Mr. Ben Bernstein on the bass. You don't want one. Oh, what a moonlight'll do to you. Wait a while till moonbeam comes peeping through. Yeah, you get more. Can't resist her, and all you'll say when you've kissed her is ooh. What a moonlight'll do. Thank you. I would be a ruler of kings. And if you were mine, I would do such wonderful things. Say it to the star, stop where you are. Light up my lover's way, and may all the stars above you obey. Okay, if you were mine, I would live for your love alone. And if you were mine, I would give up all that I own. Even my heart, even my soul, I'd give it all for you. And see, I was lucky too, if you were mine. on the trumpet. Grinta on the bone. If you were mine, I could do such wonderful things. Even my heart, even my soul, I'd give it all for you and say I was lucky if you were mine. If you were mine. Listen here, mama, I got a complaint to make. If things don't get no better, I'm gonna jump into the lake. For a long, long time, I've been your slave. Just because you got the kind of loving I crave. Do you think that's right? Mama, do you think that's right? Came home last night and you threw my dinner down to me. Then you went out at night and you stayed all night till 3. For a long, long time, I've been your slave. Just because you got the kind of loving I crave. Do you think that's right? Mama, do you think that's right? Mr. Snakebite, why don't you tell us what it is? That Snakebite on the clarinet. He's straight from New Orleans. Yeah, goodbye, mama, and the time won't be long. Let your other man take care of you while I'm gone. For a long, long time I've been your slave. Just because you got the kind of loving I crave. Do you think that's right? Mama, do you think that's right? Yeah. I tried to get in, but your other man had me barred. For a long, long time I've been your slave. Just because you got the kind of loving I crave. Do you think that's right? Mama, do you think that's right? Long, long time I've been your slave. Just because you got the kind of loving I crave. Do you think that's right? Mama, do you think that's right? Party at the end of the block. The whole neighborhood decided to flock. We had 2 live bands and a second line, filling the air with Californian kind. But the police came knocking. The police came knocking. The police came knocking, and we headed back down the road. It was a crawfish boil at 1:45, playing guitars, blowing on kazoos. Jimmy Champagne, he's trying to be the man. We didn't have the heart to tell him he was ruining the jam, but the police came knocking. The police came knocking. The police came knocking, and we headed back down the road. Come on, guys. Yeah, Cozy Fat Rosie and Skinny Joe Lynn were looking to commit the original sin. Shady O'Grady, he was cheating at cards, and we were shooting bottle rockets in the rich folks' yard when the police came knocking. The police came knocking. The police came knocking, and we headed back down the road. This is Snakebite. Give us a little bit of something. Started flaring and 2 men fought. One ran away and then the other got caught. We scraped them off off the front lawn. We would have parted real hard from dusk till dawn, but the police came knocking. The police came knocking. The police came knocking, and we headed back down the road. Just one more time now. the police came knocking, we headed back down the road. My love in Avalon, beside the bay. I left my love in Avalon and sailed away. Dream of her in Avalon from dusk till dawn, and so I think I'll travel on to Avalon. Yeah. I met my love in Avalon beside the beach. I left my love in Avalon and I sailed away. I dream of her in Avalon from dusk till dawn. So I think I'll travel on to Avalon. One more. So I think I'll travel on to Avalon. Thank you, ladies and gents, for Hobo Paradise. We'll see you next time.
let's just sing a song. And we'll laugh up and down. Oh, don't go shout when you hear them call. Let them fly right across. Oh, let them fly till the morning comes. Little angel dance. Little angel dance. Come on, come on, come on and dance. Ooh, yes, yes, that dance. Big night, bright light, all gone away to where they belong. Let's just sing our song. Bad guy, mean eye, all gone away to where they belong. Oh, let's just sing our song. And we'll laugh up and down. Oh, don't go shout when you hear them roar. Them fly right across the wall. Let them fly till the morning comes. Little angel dance. Oh, dance. Ooh, yes, 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 dance. Oh, dance. Good night, sleep tight. The big bright sun has gone away. Oh, you know it's gone away. Goodbye, don't cry. It's all gone away to where they belong. Let's just sing our song, yeah. Laugh up and down. Oh, go shout when you hear them call. Let them fly right across the road. Let them fly till the morning comes. Little angel dance. Little angel dance. Ooh, yeah, dance. once I stood beside a well of many words. My house is full of rings and charms and pretty birds. Please understand me, my walls came falling down. There's nothing here that's left for you to check with lost and found. Please read the letter that I wrote. Please read the letter that I wrote. Oh yeah. Oh yeah. Oh One more song just before we go. Remember, baby, you gotta reap just what you sow. Please read my letter and promise me you'll keep the secrets and the memories we cherish in the deep. Please read the letter, I nailed it to your door. It's crazy how it all turned out. We needed so much more. Please read the letter that I wrote. 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 Oh, yeah. can't buy my love for all the money in the world. You can't buy my love. You can't buy my love for all the money in the world. You can't buy my love. Well, you're so good, baby. I'm so glad, 'cause you done lost the best thing you ever had. You can't buy my love. You can't fortune to be told. And I don't need no Bible seller. Now these poor souls have been sold. All I want's a little loving, someone to have and to hold. And I don't need no conversation, 'cause I'm too easy to confuse. And I don't need no inspiration, but baby, you could be my muse. All I want's a little loving, someone to rock away these blues. Sock, sock, sock it to me. I love the way you do me. Sock, sock, sock it to me. Whoa, I love the way you do me. Come on and hold me tight. Make everything all right. I don't need no revolution. I heard it won't be televised. I ain't got a constitution, but that should come as no surprise. All I want's a little loving, turn my heart into my side. Sock, sock, sock it to me. I love the way you do me. Sock, sock, sock it to me. Whoa, I love the way you do me. Come on and hold me tight. Make everything all right. Sock, sock, sock it to me. Yeah, I love the way you do me. Woo, sock, sock it to me. Yeah, I love the way you do me. Come on and hold me tight. Make everything all right. Every day I have the blues. Every day I have the blues. And when you see me wild, baby, you know it's you I hate to lose. Nobody loves me. Nobody seems to care. nobody seemed to care. Speaking of bad luck, people, you know I've had my share. I've had my share. I'm gonna pack my suitcase, move on down the line. I'm gonna pack my little suitcase, move on down the line. And you know that there ain't nobody where, Lord, there ain't nobody crying.
Glenn Walters, ladies and gentlemen, our friend Glenn.
These tough times, they got me in a bind. These tough times, they got me in a bind. Feel like catching the next westbound, see what I can find. But I can't leave here without you. I can't leave here without you. I don't know what it is about you. Monday, come to your window. Monday, turn on your light. I'm in love with you, baby. Let's run away tonight. I gotta work, I gotta find my way. I gotta work, I gotta find my way. If it wasn't for your sweet love, I'd be gone today. But I can't leave you behind. I can't leave you behind. I don't know what it is, but you're always on my mind. Monday, come to your window. Monday, turn on your light. Oh, I'm in love with you, baby. Let's run away tonight. I'm just a poor boy, I ain't got no gold. I'm just a poor boy, I ain't got no gold. But I can love you, baby, till we both grow old. Well, Monday, come to your window. Monday, turn on your light. I'm in love with you, baby, let's run away tonight. Well, Monday, come to your window. Yeah, Monday, turn on your light. I'm in love with you, baby, let's run away tonight. Now see,
that's some real break dancing, because he's going to break something pretty soon. There'll be bluebirds over the white cliffs of Dover tomorrow. Just you wait and see. There'll be love and laughter and peace ever after tomorrow. When the world is free, well, the shepherd will tend his sheep and the valley will bloom again. Jimmy will go to sleep in his own little room again. There'll be bluebirds over the white cliffs of Dover tomorrow. Just you wait and see. Yeah, wait and see. Just you wait and see. There'll be love, there'll be laughter. Oh yeah, there'll be peace ever after. Tomorrow, when the world is free, well, the shepherd will tend the sheep, and the valley will bloom again. Oh, Jimmy will go to sleep in his own little room again. There'll be bluebirds over the white cliff of Dover tomorrow. Just you wait and see, yeah, wait and see. I can't stop these tears. It's useless to try. I just sit alone tonight, and I hang my head and cry. Jealousy is a hard game. Now I know the reason why. I've only got myself to blame. So I hang my head and cry. Oh, set me free. Baby, please set me free. How lonely must my poor heart be before you see it's time to part. Forever is a long time. That's what they say when you die. My punishment didn't fit the crime, so I hang my head and cry. Oh, set me free. Baby, please, please set me free. How long must my poor heart be before you see it's time to part? Oh, set me free. Oh, baby, please, please, please set me free. How lonely must my poor heart be before you see it's time to part? Don't be my baby, she got great big feet. Long little leggy, had nothing to eat, but she my baby, and I love her just the same. Crazy about that woman called Caledonia is her name. Caledonia, Caledonia, what makes your big head so hard? I love her just the same. Crazy about that woman called Caledonia is her name. Yeah, call her now. know what my mama told me? My mama says, son, you stay away from that woman because she's going to take all your money. But did I listen? No. And what happened?
Okay. Do I need to bang? So they're saying we're...
I do too.
Okay. Okay, back in open session. Is there a motion to keep confidential the matters discussed in closed session, except for an announcement?
So moved.
Second.
All in favor?
Aye.
Aye. Opposed? Hearing none, that passes. Mr. St. Croix, can you give the announcement?
At its regular meeting of January 26, 2015, in the matter of ethics complaint number 19-131115, the Ethics Commission made a determination that there is probable cause to believe the following violations of California Governmental Code and San Francisco Campaign and Governmental Conduct Code occurred, and that respondents Lynette Sweet and Sweet for Supervisor 2010 committed them. 7 violations of California Government Code Section 84200 for failing to file campaign statement 460s by 7 different required deadlines. 1 violation of California Government Conduct Code Section 84104 for failing to maintain campaign records for $61,791.33 in expenditures and for $8,750 in contributions. 1 violation of San Francisco Campaign and Governmental Conduct Code Section 1.118 for failing to pay and expense in full within 180 days of the invoice, and 1 violation of San Francisco Campaign and Governmental Conduct Code Section 1.118 for failing to pay and expense in full within 180 days of the invoice. Each commissioner who participated in a decision to find probable cause must certify on the record that he or she personally heard or read the testimony, reviewed the evidence, or otherwise reviewed the entire record of the proceedings.
Vice Chair Rennie, do you so affirm? That you do you so confirm that you
I confirm.
Reviewed the evidence? Okay. Commissioner Andrews?
I do.
Commissioner Han?
I do.
Commissioner Keene?
I do.
And I do as well.
The respondents are presumed to be innocent unless and until such time that the allegations are proved in a subsequent hearing on the merits. Yeah, but there's no
Public comment? No public comment. Next item on the agenda is the minutes. Any amendments proposed to the minutes? Public comment? Hearing none. Is there a motion to adopt the minutes?
I move we adopt the minutes.
Second.
All in favor?
Aye.
Opposed? Hearing none, that passes 5-0. Executive Director's report.
Just one quick highlight that I found out after the report had been written. Under the status of accounts at BDR, number 2, the BDR has obtained a judgment in favor of the city in that case.
Okay, public comment. Hearing none. Items for future meetings.
Oh, I only had one question. I'm sorry.
Okay.
To Mr. St. Croix. Mr. St. Croix, I wondered what happens. I was thinking about the Commissioner Keene was mentioning the anticipated cost of a particular expenditure that was doing our language conversion for all of our documents, and it's exciting to see that our actual revenues are outpacing our budgeted revenues. And for this one, it's at this point, it's year to date, it's about $15,000. What do we do with what are the typical expenditures that we spend when
We don't get
when we're
that.
in such good fortune.
We turn that money over to the city, and it goes into the general fund.
We can't have a picnic?
Okay. I've asked that before. Thank you.
Any other questions or comments on the executive director's report? Items for future meetings? Comments? Is there a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Opposed? Hearing none. Meeting is adjourned.